The first matter to come before the court this morning is City of Barberton versus James Wickwire. As you know, each party will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. And if you wish to reserve any time, if you'll let me know, I'll be keeping time today. We've read the briefs and we're ready to proceed with you all.
Thank you, Your Honors. Attorney James Reed here on behalf of the appellant, James Wickwire. I would like to reserve 5 minutes for rebuttal if necessary.
Sure.
This actually isn't a very complicated case, as you probably surmised from reading the briefs. It was a misdemeanor petty theft charge in the Barberton Municipal Court, a bench trial in front of Judge Fish. I think there was only 3 or 4 witnesses that testified in the case. I filed the brief on Mr. Wickwire's behalf, essentially making 3 assignment of errors. The first one was that I'm alleging that the trial court failed to grant the criminal rule 29 motion, and then the sufficiency and manifest weight of the argument, or against the manifest weight of the evidence argument. In my brief, I cited to a couple portions of the transcript which indicate the areas that I thought there was conflicting testimony, and that the state had failed to meet its burden of production or burden of persuasion, whichever argument you're looking at. But specifically, the argument I make on behalf of my client is that there wasn't sufficient evidence that he stole the items in question. There was a dispute as to ownership of the items. Mr. Wickwire didn't testify at the trial, but a gentleman by the name of Jeffrey Doan testified, and there was prior testimony from the landlord and a police officer that apparently indicated the landlord, although he didn't produce any documentation that he owned this particular refrigerator or particular stove, he apparently claimed that they looked similar, or they were the ones that he thought were in the apartment at, when he rented it, or I don't know, there was an upstairs and a downstairs. I think these appliances came actually out of the upstairs unit, whereas Mr. Wickwire rented the downstairs unit. But there was some conflicting testimony in that area. Specifically, Mr. Doan testified that the stove belonged to his grandmother and that Mr. Wickwire had traded with her a gas stove for the electric stove, and that the refrigerator that Mr. Wickwire owned previously. Mr. Wickwire didn't testify at the trial. If you knew Mr. Wickwire, he has quite a lengthy misdemeanor record over in Barberton, maybe even some felonies, I don't recall, but that's why he didn't testify directly at the trial. But nonetheless, there was a dispute as to ownership. And then there was also some conflicting testimony about whether or not Mr. Wickwire returned the items to the landlord's residence. The officer in question, I believe his name was Officer Gibbs, did the initial investigation, but on cross he even acknowledged that he never followed up on that. At some point during, I think it was specifically on May 4th, he went to Mr. Wickwire's residence, took photographs of it, called the landlord, went back to Mr. Wickwire's residence, said, hey, if you return these things, we won't charge you with theft, we'll charge you with a criminal trespass. And Mr. Doan testified that they did in fact return those items, but at the trial, nobody, neither Officer Gibbs testified that he never followed up on that to see if in fact the items were returned. So from Mr. Wickwire's perspective, that testimony of Mr. Doan that the items were returned remained unrefuted or uncontradicted.
What's the legal significance of your clients having returned, if the court believed that the appliance was returned, what's the legal significance based upon the challenge to the conviction of manifest weight or sufficiency? In other words, you know, the theft charge is exerting control over the property of another without permission, is there a legal significance to having returned it after the fact?
Well, as I understood from reading the transcript, the first argument that was advanced on behalf of Mr. Wickwire was it was his property, he didn't deprive the owner of the property. So I would first make that argument that there was no theft of property from another, but assuming, jumping forward to that last argument, which was, okay, he's confronted with, look, you're going to get a misdemeanor, first-degree misdemeanor petty theft charge versus, and I don't know if criminal trespass is a fourth-degree misdemeanor or whatever it may be, but that, I don't know if you want to say it's an offer or what the officer made to him, but to the extent Mr. Doan testified, and the officer couldn't confirm or deny whether the property was returned, because quite frankly, at that point, he probably is looking at it like, I've done my report, I've set the wheels in motion, this is a prosecution, and it's going forward. There was no follow-up done. I do believe that Mr. Manzi is his name, the landlord. I don't recall exactly whether he testified, whether he never got the items back or not. I don't recall. I have to look at my notes, probably why prior to coming back to rebuttal. But the legal significance, to try and answer the question, I would say that it goes back to whether, when you look at, if it's against the manifest weight of the evidence, whether the trial court, in this case Judge Fish, lost his way. And when he weighed the credibility of the witnesses and basically the evidence that was presented, that he could have found in favor of Mr. Wickwire that the property was returned. He evidently chose to disregard that testimony or not give it certain credibility when he found Mr. Wickwire guilty. But that admittedly was a little troublesome for me because they seem to be advancing two arguments. One, hey, I own the property. Two, hey, I returned the property. So not being the trial counsel, I don't know specifically what the truth may be, but under either theory, I would say that there is conflicting testimony out there, and that it remained, had the officer merely gone back to the residence and checked later that evening, he made a phone call to the landlord who lived in Toledo, and then he went to Mr. Wickwire's house, took some photographs, talked to the landlord, went back to Mr. Wickwire's house. Then he may have probably had some further communication with the landlord, turned his file over to the prosecutor's office, and the case originated and proceeded from that point. But I don't believe the officer ever went back to do the follow-up to determine whether or not Mr. Wickwire returned the property.
Well, did the landlord testify at trial?
The landlord, actually, I believe, was I don't recall if he was the first witness that the state called or the second. I'd have to look at the transcript. I thought he was maybe the first witness, but it might have been the officer as the first witness.
I'm wondering whether we'll find in the transcript whether anyone asked him whether the appliance was returned.
I think they might have. I'll check when I
And we'll review the transcript.
Okay. But I mean, there were four basic points, I guess, I would make on Mr. Wickwire's behalf. And number one is that he claimed he owned the property. That was corroborated by Mr. Doan, the only witness that testified on Mr. Wickwire's behalf. And then neither party produced any documentation as to ownership, even though they had the serial numbers and photographs of the stove and the refrigerator. Neither Mr. Wickwire or the landlord, Mr. Manzi, who claimed ownership of the stove and the refrigerator. And the officer asked both parties, let me see some receipts or documentation to clear up the issue of the ownership. And then that last point was that Mr. Doan testified that he helped Mr. Wickwire return the property to the residence. Now, I don't have personal knowledge. I can't tell you what happened, but any of those four arguments is
basis for us arguing, number one, the sufficiency, and I understand you have to view the sufficiency arguments in a light most favorable to the state, but for the weight of the evidence, it's my understanding that you get to review that de novo, and you can act as the 13th juror and kind of weigh, look at the transcript, evaluate the testimony independently, and from that perspective, I would ask you to do that and consider that Judge Fish erred in finding Mr. Wickwire guilty of the theft offense.
Thank you. And you have arrived at your 5 minutes.
All right.
If you wish to say that for rebuttal.
Thank you.
Yes.
Good morning, and may it please the court. My name is Steve App.No, and I'm here on behalf of the appellees in this matter, the state of Ohio. James Wickwire comes before you today claiming that the evidence presented in the trial court by the state of Ohio was neither credible nor reliable. Your honors, credibility is the key to this case, and the only credible or reliable evidence in the trial was presented by the state of Ohio. We, as appellees, are here to show that the trial court ruled properly based on a plethora of credible and reliable evidence. Thus, we respectfully request that you deny appellant's 2 assignments of error and affirm the conviction of James Wickwire. I would like to first start by discussing the appellant's Rule 29 assignment of error. The appellant properly cites State v. Jenks, which establishes a standard for an appellate court to sustain a conviction on appeal, and that standard is that after viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime proven beyond a reasonable doubt. Now, following that standard, James Wickwire claims that the state completely failed to present any credible or reliable evidence at the trial. However, your honors, the only evidence we presented was reliable and credible. And I'd first start by discussing Mr. Mazie. Mr. David Mazie has owned the address in question, 318 Wonderlick, for 30 years, since 1986. Obviously, he would be familiar with which appliances were located in either the downstairs or the upstairs apartment. Further, upon seeing a photo that was taken by Officer Gibbs outside of Mr. Wickwire's residence of the stove and refrigerator, Mr. Mazie did properly identify at the trial court that the stove and refrigerator were in fact his, that were located in the upstairs apartment. Also, I believe it was the Saturday after the alleged events took place, Mr. Mazie returned to the property in question. He lives in Toledo, but he maintains the property from there. After returning to the property, he took a walk around the upstairs apartment and noticed that the stove and refrigerator were in fact missing. Now, the appellant can attack the credibility of Mr. Mazie. However, the defense attorney, at the close of his cross-examination, asked Mr. Mazie 3 questions. Have you ever been convicted of a felony? To which he answered no. Have you ever been convicted of a crime of dishonesty? To which he answered no. And have you ever been convicted of a theft? To which, he answered no. Obviously, Mr. Mazie was credible, owning the property for 30 years in question, being able to properly identify the stove and refrigerator as his own.
Was there some question as to whether he said, yes, I know that those are the appliances taken out of the residence, or they look similar to?
Yes, in fact, Your Honor, at the trial, the prosecutor, Attorney Vanberry, asked him, how can you identify the stove and refrigerator as being your own? And he said, I just recognize it. It was a black gas stove with a black dial panel, and I also recognized the refrigerator. So, I mean, he didn't have any documentation, but the logical argument that we would ask this court to come to is, after returning to his property the Saturday after the alleged events took place, in which he owns, and the refrigerator and stove not being there, obviously, and he was able to properly identify the stove and refrigerator outside of Mr. Wickwire's residence as his own, we would argue that beyond a reasonable doubt, the state did prove ownership of both the stove and refrigerator. God bless you. Further, we had testimony from Officer Gibbs, who was the officer who took the photo outside of Mr. Wickwire's residence. It is true that Officer Gibbs did give an ultimatum to Mr. Wickwire stating, you can return the property at the end of the day or I'll charge you with theft. However, the appellant claims that Officer Gibbs did not return to the property, did not double check. However, at the record at page 36, the prosecution specifically asked Officer Gibbs, and I'll read it right from the record here. The question by Attorney Banbury, did Mr. Wickwire ever bring you documentation that those items were his? No. Did you take that photograph? Yes. And were the appliances ever returned? When we left that, or when I left that day, Mr. Wickwire said he needed assistance taking it down and he was going to have a friend help him move them. I've never witnessed him return them. So obviously, Officer Gibbs did follow up, noticed at the end of the day that the items in question had not been returned, and subsequently cited Mr. Wickwire with theft. Now, as this court pointed out, the appellant also states in his brief continuously that the state failed to prove beyond a reasonable doubt that Mr. Wickwire did or did not in fact return the property. However, and I believe the court touched on this just moments ago, in the statute for theft, it is not an element for the prosecution to prove beyond a reasonable doubt whether the defendant did or did not return the property in question. If Mr. Wickwire wanted to argue at the trial court level for mitigation of the sentence, surely he could do that within his legal capacity to say, I returned the property, I should not be sentenced to restitution, house arrest, anything like that. However, legally speaking, the prosecution had no burden to prove whether or not Mr. Wickwire did in fact return the property. Now, as to appellant's second assignment of error regarding manifest weight and sufficiency of the evidence, the appellant and the appellee both state the same standard that I just described for you as to the Rule 29, so I wouldn't feel the need to waste the court's time regarding the same arguments for the sufficiency standard, but I would like to point out that the appellant continually cites credible or states that this case is credible, or the state failed to present credible, reliable evidence. Yet the only witness that the defense put forward at the trial court was basically the antithesis of what is credible and reliable. The appellant spoke about Mr. Jeffrey Doan taking the stand to bolster the story of Mr. Wickwire. Now, upon taking the stand, and I'll read again from the record at page 54, beginning with his cross-examination by Attorney Banbury, she states, Mr. Doan, you're friends with Mr. Wickwire, correct? Yes, ma'am. And it's fair to say you don't want anything to happen to him, right? Correct, ma'am. And you've testified in cases before for him, right? No, ma'am. You didn't testify in this courtroom when he was charged with dog at large? For this case, I have testified yes, because I was in that. I was a part of that. So you've testified in cases before for Mr. Wickwire, correct? Yes. Now, Your Honors, I can't speak for everyone, but if I testify on someone's behalf, I tend to remember that. I'm not saying that I have, but if in fact I had, that would be something I would remember. It wouldn't be something that would skip my mind. Then 2 sentences later, oh yeah, I remember I did testify for this man. So obviously his credibility had already been lowered at that point by the cross-examination. But the further cross-examination of Mr. Doan revealed that he has an extensive criminal record and that he has been convicted of crimes of dishonesty in the past. Thus, if this court is to weigh credibility, if this court is to weigh reliability, on one side we have 2 credible witnesses, Mr. Mazie and Officer Gibbs. And on the other side, we have a non-credible, non-reliable witness in Mr. Doan. Thus, as to the sufficiency, we would just argue, when the evidence is viewed in a light most favorable to the prosecution, that the rational trier of fact in this case, Judge David Fish, did find that the state's witnesses were in fact more credible than the defense witnesses. Now, as to manifest weight, the appellant properly cites State v. Auden, which establishes the standard for an appellate court reviewing a claim of manifest weight. They must review the entire record, weigh the evidence and all reasonable inferences, consider the credibility of the witnesses, and determine whether, in resolving conflicts in the evidence, the trier of fact clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed and a new trial ordered. The appellant bolsters that standard in his brief with State v. Tompkins, which states that a weight of evidence challenge indicates that a greater amount of credible evidence supports one side of the issue than supports the other side. And Your Honors, we would just argue again that if you were to take into consideration the credibility of the witnesses, if you are to find that a greater amount of credible evidence supports one side than the other side, we as the state believe that we have shown beyond a reasonable doubt that our two witnesses were in fact credible, were reliable, whereas the lone defense witness, Mr. Jeffrey Doan, was not credible, not reliable. The trier of fact in this case, the trial court, clearly did not lose its way in determining the credibility of the witnesses. Excuse me. And thus, there was absolutely no miscarriage of justice. The Judge Fish, stated as much at the end of the trial. I believe it was right before sentencing. He stated, I believe the state's witnesses are in fact more credible than the defense witnesses. Your Honors, the appellant wants you to find that after reviewing all the aforementioned evidence, in a light most favorable to the prosecution, that the trial court acted irrationally by finding the essential elements of the crime were proven beyond a reasonable doubt. The trial court did not act irrationally. The trial court did not lose its way. It acted as any rational court would after reviewing and considering all the evidence presented. Based on the presentation of the witnesses by both the state and the defense, no rational judge would find that Jeffrey Doan is in fact more credible or more reliable than Mr. Mazie or Officer Gibbs, nor that the state failed to prove every element of the offense of theft beyond a reasonable doubt. We showed through testimony that Mr. Mazie owned the items in question, that they were deprived, that he was deprived of their ownership, that Mr. Wickwire exerted control over those items, being present at the side of his house when the picture was taken, and that he did so without Mr. Mazie's consent. To characterize the trial of James Wickwire as a miscarriage of justice, which would need to be done in order to overturn the conviction, would be a miscarriage of justice in and of itself. Thus, we respectfully request that you deny appellant's 2 assignments of error and affirm the conviction of James Wickwire imposed by the Barberton Municipal Court. Thank you.
Thank you.
Just briefly, Your Honors, I did have a chance to review the transcript, although I don't recall the exact question. Mr. Manzi testified first, then Officer Gibbs, and then Mr. Doan. And on the issue of whether the property was returned, apparently that issue was never raised with Mr. Manzi when he testified first. That issue kind of arose when the officer gave his testimony, and then Mr. Doan, on pages, I believe, 53 and 54 of the transcript, went into some detail about they brought the property back, put it outside the house, but Mr. Manzi never specifically testified one way or the other on whether the property was returned from my rather quick review of the transcript. Okay. All right, thank you.
Thank you both for your presentations. The court will take the matter under advisement. We will issue a written opinion, which will be sent to both sides, and you may certainly check the Ohio Supreme Court website or our website as we post them in both places. Thank you.
Thank you.
Have a good day.